History as it happens, May 30th, 2023. Constitutional myth.
I, Franklin Delano Roosevelt, do solemnly swear
I, Harry S. Truman, do
that I will
solemnly
faithfully execute
I, Dwight D. Eisenhower, do solemnly swear
preserve and protect and defend the Constitution of the United States. So help me God. So help me God.
I, Jimmy Carter, do solemnly swear
That I will faithfully execute.
that I will faithfully execute
I, Ronald Reagan, do solemnly swear
That I will faithfully execute the office of President of the United States.
that I will faithfully execute the office of President of the United States.
And will, to the best of my ability,
preserve, protect, and defend the Constitution of the United States.
preserve, protect, and
preserve,
defend.
protect, and defend the Constitution of the United States.
So help me God.
So help me God.
So help me God.
So help you God.
So help me God.
Americans, at least many of them, revere the Constitution and the men who framed it. It is the document every president since Washington has sworn to preserve, protect, and defend. Our Constitution was, and still is, a contested document, the source of ongoing political conflict since the ratification debates, from which myths originated, under which we still labor, says Jack Rakove, and he's next as we report history as it happens, a podcast from the Washington Times. I'm Martin DeCaro.
Well, the main source of American identity is really the Revolutionary era. The big problem we face is, in a certain sense, is how do you integrate the events of the 1770s and 1780s with the events of the 1860s? The Revolution on the whole, notwithstanding the current fuss and tumult over exactly how to interpret it, retains its kind of primordial place in our consciousness. We're still bitterly divided over the Civil War and its outcome. And the question of how you treat that, and A, by itself, and then B, how do you relate it to the founding year proper, continues to vex us still.
Sometimes I get an idea for a podcast by simply opening up my laptop in the morning and taking a look at Twitter. That's what happened on May 17th. I spotted a tweet by historian Jack Rakove, who's written or edited dozens of books on the American founding. Rakove posted a link to an essay he wrote in the Journal of American Constitutional History. His essay criticized a chapter in a new book titled Myth America, and that chapter was written by Yale legal scholar Akhil Amar about constitutional myths. Now, Rakove argued the myths Amar chose to debunk, such as James Madison was the father of the Constitution, aren't myths at all and possess little relevance to the vexing political problems of our own time. Now, for the record, Amar says George Washington can claim paternity of the Constitution more so than Madison, but I can't say I've ever overheard anyone debating this point. I do hear people concerned the Supreme Court has badly misinterpreted the original meaning of the Second Amendment as mass shootings continue to fill headlines. And this is Rakove's point, too. There are myths and spurious arguments made about our founding documents that endure to this day, contributing to the extraordinary stress Rakove says our constitutional order is under.
I hope Mike Pence comes through for us, I have to tell you. I hope that our great vice president comes through for us. He's a great guy. Of course, if he doesn't come through, I won't like him quite as much. I hope we are going to have in this country the biggest protest we have ever had in Washington, D.C.
Was your vice president, Mike Pence, who says that you endangered his life on that day.
I don't think he was in any danger.
Mr. President, do you feel that you owe him an apology?
No, because he did something wrong. He should have put the votes back to the state legislatures, and I think we would have had a different outcome. I really do.
But he doesn't have the authority to do that, as you know.
What?
The vice president does not have the authority to reject those election results.
Are you ready? Let's have this one out just now, because it's interesting. Let's keep it interesting, right? I like Mike Pence very much. He's a very fine man. He's a very nice man. He made a mistake. His lawyer said, you cannot move. I called him the human conveyor belt. I said, even if the votes, I talked to his lawyer, even if the votes are absolutely fraudulent, he can't say, yes, sir, he can't send back. And the Democrats played it, and the rhinos played it.
Ex-President Donald Trump in that CNN town hall, and for the past 2+ years, has insisted the vice president has the authority to reject electoral college votes, that the Constitution should be terminated because he lost the 2020 election. Now, these crazy ideas may be Trumpian innovations, but the Electoral College itself is certainly not a new problem. And the Electoral College is among the issues we're going to discuss here now, because when I saw Rakove's essay, I sent him an email inviting him on, and we're lucky he said yes. Jack Rakove, Emeritus Professor of History and Political Science at Stanford University. Welcome to the podcast.
Great to be here.
It's an honor to have one of our great historians of the founding era on the show. And, I wasn't planning on doing this until I saw in my Twitter feed one morning. Well, first of all, I didn't know that you were on Twitter. I saw your article in the Journal of American Constitutional History about constitutional myths and what is a myth versus, say, a lie or just a spurious claim. So welcome. It is truly great to have you here.
I'm very happy to be able to join your show.
I assume that you're delighted, as many historians are, to see history in play in our news so often today, that people are thinking seriously about these issues. Although my own sense is there's still just as much confusion out there about the past as there's always been.
Well, thanks to the First Amendment, so long as it's still in effect, we have an open marketplace for ideas. So lots of legitimate scholars can join the fray, and a number of my colleagues, I think, have done so quite successfully the past few years. And on the other hand, lots of wretched or flawed or problematic ideas can flourish too. So they flourish in the social media. Some of us think they flourish in the Supreme Court in a lot of its jurisprudence, which purports to be historical, but which gets many aspects of the story wrong. So it's one of the consequences of the First Amendment. I mean, Jefferson's theory was we argue all these things out, and over time we'll get to a better understanding. But it seems to me the judge and the jury are still out on terms of the outcomes.
I would say yes and no on that score. It depends on who you're reading. I mean, the 1619 Project is a great example of this. I've done a lot of episodes about it. I know that you're a critic of it. And this issue about the American Revolution being fought to defend slavery or protect slavery, I don't know if that's a myth. It's more of just a spurious claim or a lie at this point. But,
I would call it a myth. I'm not a critic of the 1619 Project in general. It is quite original. It's quite ingeniously conceived. In its own way, it represents real contribution. I think its main claim that if you want to look for evidence of the impact and the extent of systematic discrimination, particularly directed against African Americans, there's lots there to be found. I mean, I do think as a historian, though, it's wrong on two counts. One is, I don't think 1619 was that big a deal per se. It's an interesting year to talk about if you're an early Americanist, which I was by training. The idea that the future of slavery was set in 1619, I think, is historically flawed. You really need to really go down to the late 17th and even the early 18th century. And of course, and then the other problem is that I do think the claim, and this is a subject I've written extensively about going back literally the 1970s, the idea that the decision for independence is somehow based on the need to defend slavery.
The Dunmore
Proclamation, or a more general belief that there's some anti-slavery movement growing in Britain on the basis of the famous Somerset case of 1772. That just seems to me to be a terribly flawed and downright erroneous argument. So I like the project in general, but a lot of the specific claims, I think, are particularly the ones relating both to 1619 itself, the literal year, and to 1776 are mistaken.
Well, the American Revolution is quite a topic to get that badly wrong. But anyway, maybe we'll return to 1619 at some other point. As I was reading your article, which is not about the 1619 Project, in the Journal, it's really about an article written by Akil Amar in a book about constitutional myths, where you say he's not really addressing real myths and that you have your own series or set of constitutional myths that are more relevant to our own problems in our country today. As I was reading the article, I kept saying, yes, terrific, excellent, because it's kind of why my podcast exists. You say here, getting the story straight does matter today because Americans still inhabit the political world the framers created. You also say one charm of doing history is that the occurrence of unexpected events inspires or compels us to ask new questions about a past that seemed too familiar to merit fresh examination. Or as I say, and I borrow this from Christopher Clark, the subject may be old, but the issues are fresh. So in many of my episodes where I've talked about why do we keep going back to the framers and the founders, these 18th century men? Why is it so important to consult them for guidance or to disagree with them? Well, we're still living with their Constitution. It's pretty obvious answer. Maybe I've been seeking too profound a question.
Well, the main source of American identity is really the Revolutionary era. The big problem we face is, in a certain sense, is how do you integrate the events of the 1770s and 1780s with the events of the 1860s? The revolution on the whole, notwithstanding the current fuss and tumult over exactly how to interpret it, retains its kind of primordial place in our consciousness. We're still bitterly divided over the Civil War and its outcome. And the question of how you treat that, and A, by itself, and then B, how do you relate it to the founding year proper, continues to vex us still. So that's one big aspect of this. I think the second thing is in one of my major criticisms of Akil Mar's article, it's not a criticism of the article per se, it's a criticism of the opportunity he missed because he wanted to recycle what I think are some of his old and somewhat tired interpretive themes, is we are living through a genuine constitutional crisis of a kind we never would have imagined. That's to say, every American every thoughtful scholar or commentator has assumed that ever since the election of 1801, the concept of the peaceful transfer of power from one election to the next has always been the core principle of our democracy. The more one thinks about the election of 2020, and not just January 6, 2021, but the evidence for a lot of prior planning preceding what happened on January 6, 2021, it's clear that there was a sustained plan to find a way to circumvent the attested results of the election. So
the slates of fake electors in some states.
Yeah,
right?
and so on. Yeah. So, for all this to take place means we have to try to identify what were the structural weaknesses or what were the structural shifts in American politics and political culture that made January 6th and the antecedent events possible. It's been a real novelty for me because I'm mostly an 18th century historian. So, I know how the story came out. It's like to say you never know how a book's going to end until you write the last page.
That's right.
But usually you know what the conclusion is going to be. But now I'm writing a political history of the Constitution, which is supposed to come down to the present. That's my main project now. And since I no longer know what is the status or security of the Constitution, it's raised all these questions I'm still actively wrestling with.
Well, I got two words for you. Electoral college. It's never made much sense to me, or more so recently. And based on your article in the Journal, it didn't seem to make much sense even then. How they agreed to it, they then decided, talking about the framers at the Constitutional Convention, you say maybe out of exhaustion, they just simply deferred back to the states on how to pick the electors. Right. And I will admit that I have subscribed to a myth about the Electoral College. You have set me straight. I once believed that one reason for it was that the founders worried about demagogues and did not trust a direct democratic election of the chief executive. So the Electoral College, for one reason, was put in place as a check on that. You're saying that's not the case.
No, I wouldn't agree with that. Martin, I think the best way to think about the origins of the Electoral College, which is a complicated subject, first off, your starting position has to be to appreciate the novelty of the problem that the framers were trying to solve. In this sense, there was no model available of how you would choose a national Republican, lowercase r, a national Republican executive. You had monarchical government, which the Americans as Republicans had rejected. You had the form of kind of constitutional monarchy with ministerial government that existed in Great Britain. But the Americans had also rejected that. If you read the work of my mentor, Bernard Bailyn, always emphasized in his great book, The Ideological Origins of the American Revolution, the way in which the belief in a ministerial conspiracy was one of the axioms or one of the underlying assumptions or presumptions that guided revolutionary thinking before 1776. So there was no example of how do you actually go about doing this. So I think number one is, as I said in a couple other places, it's what I call the cut them some slack rule. Before you criticize the framers for coming up with the outcome they did, I think you have to appreciate the difficulty of what they're trying to do.
Absolutely.
So that's my first point. Second point is the debates within the convention from June, through mid-September 1787 were driven by the relative disadvantages of the three major modes of presidential election. The most obvious way to do it would have been to have the president or the chief executive elected by Congress. But if you want to do that, And you also believe in kind of principles of having a constitutionally independent executive and a kind of broad theory of separation of powers. If you have election by Congress, that means the president can only serve a single term. If he's going to be subject to congressional reelection, he'll become the lackey, the tool of whatever congressional majority is going to put him in power. So if you have a strong belief in separation of powers, which a number of the framers did in complicated ways, legislative election is not a good idea unless you want to have a single term president. But a number of framers, Hamilton, I think, is the best example of this, happened to think, and I think this is a really intriguing idea, that the incentive to reelection would actually be the best guide or the best inspiration to proper statesmanship, to proper presidential behavior. Those turned out to be kind of decisive objections against legislative election. Popular election is the most obvious alternative. The first objection to that, the one that Akhil Amar emphasizes with some merit, but I think in the end incorrectly, is if you have a popular election of the president and there's only one constituency, let's call it the United States of America. If you have a truly popular election, the states are not part of the equation. A truly popular election means every entitled voter has one vote, and you just simply have a national constituency. That would disadvantage the South because of the demographic imbalance that's related to slavery. Madison raised that objection at an early point, and that's what Akhil Amar and others have jumped on. But then he abandoned it. Abandoned it and says, okay, popular election is the best. And it's my hypothesis, and Martin, what you were reacting to earlier, is I don't think it was the fear of demagoguery that made the framers nervous about popular election. It was the fear of indecision, that you'd have to assume in a dispersed national electorate, it would be hard to get a decisive choice, or at least without imagining some round of voting. In fact, that turned out to be a big miscalculation. As soon as you got to 1796, you could have had an effective choice between two preeminent national candidates, also 1800.
So the electorate was tiny, too. Sorry to interrupt.
It's not so much in size as but the key factor here is its size and its dispersal. And so there's a failure to anticipate that actually, if you have as powerful a figure as the president was becoming, that would create an incentive for interstate competition, interstate coordination to identify strong national candidates. So I think the Electoral College emerged as the alternative to this. It had one advantage. You could combine the two compromises the framers had already made over representation. The more populous states would have the advantage in the first round of voting, but assuming you didn't reach a majority for any candidate, and you had the contingent election eventually in the House of Representatives, then the small states would have a greater advantage under the equal state vote principle, since the House of Representatives would vote by delegations, not as individuals, but by delegations. But in the end, the key thing, and we're still, in a certain sense, we're still wrestling with this still, is so the framers reached that agreement on the basis of what's the basic rule for apportioning electors and the different phases of the election, but they didn't decide how electors themselves were to be appointed. When you get to 1800, the number of states which changed their rules out of partisan calculations was actually quite large. I mean, so in fact, I think in a sense the framers ran out of gas. That issue was, it was really the last issue they were deciding.
And the gist of your article is the Electoral College is one of those issues that's important for historians to discuss today because it's still causing problems today. I'd like to get rid of it. That's not going to happen. But,
so would I.
My initial question about why do we go back to the founders? Why are we still entangled in the late 18th century? I wonder if people in other countries do this. Do the French talk about Napoleon? Well, yeah, sure, but not in the same way, right? Because they're on their 18th different constitution since then. I guess the Napoleonic Code is still a thing, but other countries are not still living with a political framework created in the 18th century. So there is the difference there, if you get my point. But that doesn't mean our hands are tied, to bring it back to the Electoral College and some of these other issues that you believe historians really should be talking about in the public sphere because they're causing so many difficulties today, such as the Second Amendment. What is the myth about the Second Amendment that's causing us problems today?
The myth about the Second Amendment is essentially the doctrine that the Supreme Court adopted in the D.C. versus Heller case, with Justice Scalia's opinion for a 5-4 majority in D.C. versus Heller, the 2008 case, which made the claim that the Second Amendment also protects an individual right of self-defense, at least within the home. And if you look at the last term's Bruin decision, which I think is a true, Heller was bad enough. Bruin is a true disaster. And because a lot of the cases being litigated applying Bruin are basically authorizing people to carry automatic weapons in public places without any considerations of safety or the intimidation of citizens or just the fear factor that it injects into any of a number of communities. I was the main author of the historian's brief in DC versus Heller. Anybody who looks at the historical record, who looks at what was actually being debated in 1787-88 when the Constitution was being ratified, or what the ongoing concern was in 1789 when Madison introduces his proposed amendments to the Constitution, the discussion was all about the militia. And the reason that the militia was the subject of discussion was in part that under Article 1, Section 8, Clause 16, which is the list of the enumerated powers of Congress, the states have the residual authority to create the militia, but Congress has given the statutory authority to pass superseding legislation relating to how it's going to be organized, armed, and disciplined. And a number of anti-federalists took that criticism as being a real threat to the existence of the militia. That's what they were debating. There were a handful, but when I say handful, I mean literally like 2 or 3 references in the extensively recorded debates over the ratification of the Constitution to what might be regarded as a personal right of self-defense. But the Federalists kind of scoff at those. So it seems to me that when Scalia and the 4 other yes votes on DC versus Heller, although they try to dress it up in kind of pseudo-historical framing, basically they got the story wrong. There always was a common law right of self-defense. Whether you call it stand to the wall, which was, the prevailing doctrine, meaning, or retreat to the wall, meaning in a violent situation, your first obligation would have been to try to steer clear of it rather than intervene. And now, of course, we have the kind of stand your ground interpretation, which is gaining prominence, particularly in a lot of red states.
People have been shot to death because of arguments.
Oh, I know. Even the riot. I just read a set of tweets the other day, like 6 separate road rage shootings in different states across the country, just completely gaga. I'm not sure that's a myth so much as a misinterpretation. I mean, there is historical evidence out there. I think our side read it better. I know from personal evidence that Justice Stevens, who wrote the dissent in DC versus Heller, and who also, like me, was a Cubs fan, and he actually went to the World Series in 2016.
There you go.
I know Justice Stevens followed our brief in the dissent in DC versus Heller.
Didn't Justice Berger some years ago say that the common or the modern interpretation of the Second Amendment is a massive fraud, right?
The modern claim that the Second Amendment protects an individual right to bear arms is a massive fraud.
And that meaning that we cannot regulate guns at all.
This has been the subject of one of the greatest pieces of fraud, I repeat the word fraud, on the American public by special interest groups that I have ever seen in my lifetime. A well-regulated militia. If the militia, which was going to be the state army, was going to be well-regulated, why shouldn't 16 and 17 and 18 or any other age persons be regulated in the use of arms?
So is originalism a myth?
No, originalism is historically grounded. The last chapter of my book, Original Meanings, talks about Madison and the origins of originalism. There is a famous speech that Madison gave on April 6, 1796. It's in an ongoing dispute over the enforcement of the Jay Treaty. It's John Jay, who had been Chief Justice, had negotiated with Great Britain, back in 1794-95, where Madison says, in effect, endorses a form of originalism, which says it was not the intentions of the framers of the Constitution, but the understanding of its ratifiers is what made the Constitution supreme fundamental law. And therefore, to understand what the Constitution means, it is legitimate and useful. I'm not sure Madison says it's absolutely necessary, but at least it's legitimate and useful to try to understand how different provisions were understood at the moment or at the time of their adoption. There are a lot of technical problems with what Madison was doing. The specific debate, he relies upon material from the North Carolina Ratification Convention. North Carolina was the 12th state to ratify. North Carolina was not part of the Union in 1789 when the new government was organized in New York City under the Constitution. It ratified later. So to rely on North Carolina, which in a sense is a latecomer to sustain this proposition is, I mean, it's not totally wrong, but it is somewhat problematic. But originalism itself does have a genealogy which you can run back to the late 18th century, let's say to post-1788, but close enough to the adoption of the Constitution.
Well, what is the intent of the founders when the founders themselves disagreed on everything?
Well, yeah, my position would be that what historians can do, I mean, let's go back, Martin, to your general claim about the utility of being a historian. What historians can do, because we're trained to identify every source that's out there and to try to weigh its evidentiary value, is I think the best thing historians can do is to try to reconstruct the debates over particular clauses. As I say, I'm just a historian for the working day, or a working historian. So I don't have a privileged position in one sense as a legal commentator, but I happen to think, just thinking about this as a citizen, that any attempt to figure out the meaning of the Constitution ought at least to begin with some understanding of what we might call its legislative history. What were the concerns that led to the different provisions being adopted? And then, in a sense, that's what I really tried to do in my book, Original Meanings. I assumed at the time, and actually, to be honest, I started thinking about this 50 years ago. I actually started thinking about originalism before the term itself existed, back when I was a graduate student in the early 1970s, mostly over the impeachment of Richard Nixon. And I came from a Nixon-hating family. And also the War Powers Resolution of 1974. Lots of arguments were made that appealed to the debates of the 1780s. And I said, oh, this is kind of interesting.
Yeah.
It seemed to me all these questions were inherently historical.
Rogue executive, that was a fear.
What is the executive power vested in the President of the United States? The first sentence of Article 2, which is still a major source of constitutional dispute and intellectual dispute today. So I started to think these questions are inherently historical in nature. The curious thing that's happened here is that, perhaps in part because doing history is hard work, and also because it may not give you definitive results. I mean, if you're reconstructing the debate, it may be different from saying you can really attain a high degree of confidence that a level of consensus was attained. So the dominant form of originalism today is what's called semantic or public meaning originalism. And it presupposes that there's some linguistic approach to figure out what each term or what each clause would have meant to an educated reader at the time. You can use the historical evidence not because it demonstrates why the clause was there in the Constitution, what purpose, what function was the clause meant to serve. You use it because the commentaries in the Constitution will provide evidence not of a historical nature, but essentially of a linguistic nature. This strikes me as being terribly perverse, but that's the dominant form of the originalism takes today.
As a historical matter, James Oakes brings this up with me all the time when he's on the show. The Constitution was a contested document. Rather than trying to take a side about who was right, the people who said it was a pro-slavery constitution or an anti-slavery constitution or somewhere in between or elements of both, which I think is probably the most accurate way of putting it. The more important point, though, is that it was contested. Some people developed an anti-slavery constitutionalism to challenge the slave power. So that wasn't really a question, Jack Rakove. It was more of a speech. But I mean, that's how I look at the Constitution. As a matter of history, it's been contested, and that there was no single way to interpret, as we know, some of the clauses in it, like the Privileges and Immunities Clause, which needed the Civil War and the amendments passed after it, ratified after it, to finally straighten that out.
Yeah, well, I sort of agree with you on the slavery question, and I sort of agree with Jim Oakes on this as well. And since the current book I'm working on now, I'm going over some of this material. I spent a lot of time a year ago going through the Missouri question, crisis, controversy debates. And I think you do see embedded the points that we're still disputing today, or the people like Jim Oakes and Sean Malentz on one side would dispute with their critics on the other. And I think there's a curious way in which historically the ongoing debates work to reinforce the original divisions. I mean, even the way in which Jefferson is treated. There's the Jefferson who Lincoln admired as the author of the Declaration of Independence. There's the Jefferson who condemned slavery in the notes on the state of Virginia. But there's also the Jefferson who supported colonization, and the Jefferson who, in another famous passage of Notes on the State of Virginia, suggested that blacks were racially inferior, and really did introduce all these racist themes in American political thinking that we're still contending with today. But I think Martin, I think it's right to say that what historians can best contribute is less to come up with a definitive reading, though I think actually in some cases, I mean, my point about the Second Amendment makes this perfectly well. I mean, I think in many cases, some readings should be much more persuasive than others. But I think our starting position is to reconstruct the debate. Yeah. And then ask to what extent can we say it reaches, kind of a finite focused conclusion on the one end, or to what extent does it remain open-ended? I mean, a great example of that would be, what do we mean by an establishment of religion? There's a variety of definitions out there. Everything from, does it mean actually giving legal superiority to one particular sect or denomination? Or does it mean, which I actually think is the case, the best example would be that Americans in the 1780s, 1790s believed in what we might now call non-preferential establishments. That if you had any form of established religion, if it were done non-preferentially, that might be a benefit. To the idea that any, the kind of Madisonian, Jeffersonian idea, that any public support for religion would be improper. So again, you have a debate, you have multiple possibilities out there. The historian's job, I think, is to sift the evidence as best we can and try to determine which readings are more, which readings are less sustainable, authoritative, and so on.
Well, the interpretations I find definitive are the ones that square with my own personal politics, and the ones that are open-ended, well, Well, here's another myth that you want to tackle, the republic versus democracy debate. Which one are we founded as? Which one were we founded as, rather? You're saying it's not a one or the other, that these words were often used interchangeably. I mean, this one, depending on which historian I'm speaking to, I get different takes on this.
Yeah, well, this is the one part of Akil Lamar's original article that I was responding to, the Founding Myths article in the Myth America book, that I actually found most persuasive. There is a story out there, and I haven't checked this on my own, but I think a number of commentators suggested that this idea of distinguishing a republic from a democracy is representing some useful motif in constitutional interpretation. It actually originated with the John Birch Society, which is as far,
lunatics.
Far right. Well, that's one way to characterize
Well,
them.
The fluoridation of water stuff. Well, go ahead. Yeah.
Right. Yeah. Peacher Award. I mean, they had a lot of pet causes. The point I made in my own article is that argument makes most sense if you want to say we're a republic and not a democracy. Well, if you're a democracy, then the more democratic you are, the implication is the more you believe in majority rule, tout seul, just by itself. So if you say a republic, I think it implies, or latently it suggests, that no, we have other criteria out there that might be counter-majoritarian in nature that we somehow have to fulfill. And I think the problem with this is that the point I try to make in my own article is it was quite frequently used in, let's say, the debates over the Constitution, 1787-88, to talk about the House of Representatives, or to talk about the lower house of the Assembly, to talk about the state legislatures, as the most democratical branch of government. So even if you're trying to found a republic, after all, we have the Republican guarantee clause of the Constitution. We don't have the democracy guaranteeing clause of the Constitution. And Madison was the original author of the Republican, or the proponent of the Republican guarantee clause. So you might say, well, they chose one word and not the other, and so maybe that implies one is more valuable or useful or authoritative than the other. But on the other hand, it was quite common use to say that the lower, whichever branch of government is most directly representative of the people will be by definition, or almost tautologically, the most democratic. They would sometimes say the most democratical branch of government. And if you spend a lot of time with James Madison, which I do pretty much on a daily or sometimes an hourly basis, because I am a big Madisonian as a scholar, Madison's main fear, his main concern, or the problem that was really driving his constitutional thinking in 1787, 1788, was the idea that the popular elected branch would be the most powerful and dangerous of all. So you could say that even if Madison said we're trying to be Republicans, which was, let's say, the theme of Federalist 39, in effect, he was wrestling with democracy. So to distinguish, there is a kind of nominal distinction you can make and you can tease out its significance, but operationally, it seems to me it kind of breaks down. It's useful to know what the conceptual history was, but also to realize that there are some limitations of that history itself.
Well, isn't it true that the framers, the founders, were concerned about swoonish popular opinion? They didn't altogether trust ordinary people. And there are, indeed, counter-majoritarian, by design, structures in our political framework. the Senate, right? The 2 seats to every state, no matter the size. And well, why don't we talk about that Senate issue here? You're saying that it's a myth that there was a compromise over how to determine representation in the Senate. There was no compromise. There was a vote. One side won, the other side lost.
Right.
And
the original decision on July 16, 1787, there were 10 states represented. It went 5 states to 4 with Massachusetts, which was a populous state, along with Pennsylvania, Virginia, was one of the 3 most populous states, with Massachusetts divided by the votes of Elbridge Gerry and Caleb Strong. So, and then, the next day, the large state delegates get together. They try to say, do we want to break up the convention? Should we just go our own way? Should we just say, okay, well, we reached this decision, we regret it, but we have to push on? Eventually, they opt for the last option. So originally, there's no compromise there. I mean, it's sometimes suggested that, well, the compromise is to have a bicameral legislature instead of having a unicameral Continental Congress. But that issue was never in dispute. I mean, the framers of the Constitution agreed pretty much from the get-go, and this is a very Madisonian position, that the new national government had to have its own legislature. And say it couldn't just enact resolutions, requisitions, recommendations. It had to be able to enact statutes. And to enact statutes, given the conventions of American thinking, you needed to have a bicameral legislature.
And you refer to these as urgent constitutional matters, not just in those days, but they're urgent for us today. And one aspect of this debate about myths or how the framers decided upon representation in the legislature, it's untrue that they believed at the time people in smaller states had different interests and preferences than people in larger states. So why do we still believe that today? Because it makes no sense and it's causing problems. Is that kind of what you're arguing?
Up to a point.
Okay.
So, Martin, let me try to clarify what you said.
Clarify my word salad there.
So when you said they, the position I'm taking, again, a very Madisonian position. The key point that Madison wants to make is, do the large states have common interests? So the 3 large states, the 3 most populous states, the largest states are Virginia, Pennsylvania, and Massachusetts. Actually, its position owes a lot to the Baron Montesquieu. A lot of this logic comes out of de l'esprit de loi, the spirit of the laws. Montesquieu's great, if rather puzzling work, is that the preferences, the interests of the citizens of those states are not a function of how populous the states are. Pennsylvania is a major grain exporter, and Pennsylvania is bountiful. Virginia is still relying on tobacco, an export-oriented commodity. And of course, Virginia is a slave state. Slavery is legal, but is pretty much morbid in Pennsylvania and Massachusetts. So you have slavery versus freedom. You have a different religious configuration. Virginia is kind of primarily Anglican. Pennsylvania is already a multi-denominational society. Massachusetts remains primarily congregational, although there are some Baptists who are starting to make trouble. You have all these sociological variables that determine what the real interests and therefore the preferences either of voters or their elected leaders are. Nobody either then or now would say, I always put this question to my students, do large or small states ever, as such, do they ever have a common interest? Do we ever vote on the basis of what's good for the large states or what's good for the small states? So I press my students on this, and they can't come up with an answer. I said, but there is, I said, you're right, there is no answer. So Madison was basically right, but there is one exception. When you're voting on rules of voting, and you have the precedent, which was derived from the Articles of Confederation, of giving each state an equal vote, you have a prior commitment, or let's say a prior advantage that you're trying to protect. And this really matters today because, the Senate, the situation is going to get worse. The disparity between, the amount of the population represented by the most populous state and they're represented by the small states, it's not going to get better over time. It's going to get worse. And of course, it's also incorporating the Electoral College.
I agree. I've lived in Rhode Island, small state, population. We're talking in terms of population because Alaska is a small state.
Right.
And I've lived in California, and the way I view things had nothing to do with the amount of neighbors. Well, this is what you write here, and you put it beautifully, unlike my question, so thank you for hanging in there. You wrote here in your article, the idea that small states have distinctive interests of their own is the primordial myth or constructive fiction in American constitutional history. It resonates today, you say, in ways that implicate underlying problems in American governance. These are pretty big claims, Jack Rakove. You say it justifies not only the equal state vote in the Senate, its original inspiration, but also other procedures like the filibuster, which amplify that inequality rather than modify its injustice. You know, we're not stuck with any of this stuff. There's a procedure in place to change things. It's called amending the Constitution. Of course, it's very hard. But do you get the sense that some people on the left are just abandoning the field to those on the right? And they're not claiming the Constitution, the Bill of Rights, and the Declaration of Independence and the founders as their own anymore.
Yeah, well, Bart, you're really asking me two sets of questions,
yes.
I think. I mean,
that's my style. I just inundate my guests with words.
Well,
no, go ahead.
One is about the amendment procedure, and actually I made the point in passing in my piece you're referring to, is that the framers actually thought they're making it easier to amend the national constitution than more difficult. Today we say it's impossible to amend it. Why even bother? But, under the Articles of Confederation, the first national constitution, there's only one way to amend the Constitution. Continental Congress had to propose it, and all 13 state legislatures had to ratify it. And that proved impossible. And that's why, in effect, the framers of the Constitution basically threw that rule out and said, we're going to come up with a new set of rules of our own. But Article 5 actually gives you two ways to propose and two ways to amend, and it reduces the unanimity requirement to the 3/4 of the states have to approve.
Yeah, and dudes like Jefferson wanted there to be changes with each generation.
Well, Jefferson's his own story.
Yeah, he wanted a constitutional convention every generation. But go ahead,
Yeah, Martin, I think it's true to say that you can see this, a lot of evidence for this in the funding, that people who are intellectually or politically on the right are much more invested in preserving what they perceive as the existing or standing constitutional order than people on the left are. I mean, I think of myself as being an originalist in terms of my scholarship. I'm not far on the left. I like to describe myself as a native Cook County Democrat and a native Chicago Cubs fan. So I'm a kind of moderately liberal. Yeah, I'm more of a conventional Adlai Steve and FDR, kind of liberal Democrat from the mid-20th century. But I do think it's true that there is a real asymmetry in the amount of nominal loyalty or fealty that people on the right pay to what they perceive to be the Constitution. I think people on the left are more skeptical about it. People on the left are much more inclined to say that, in fact, what really makes the Constitution work was less the genius of the framers or less the genius of the founding generation. It's really the belief in two foundings, or really three. You could say the first founding is the late 1780s. The second is the Reconstruction Amendments. But as I used to tell my students, the failure of Reconstruction was arguably the worst tragedy in American history. So then maybe you need to integrate the second Reconstruction of the 1960s into the story. So I think progressives have a dynamic view of history. This is a dynamic and positive view of change over time that conservatives nominally abhor, or maybe more than nominally. I do think the founding period remains, and the Civil War period remain kind of the dominant beacons in our historical memory. There are reasons why we lionize Washington and Lincoln. And to some extent, FDR, though, FDR wouldn't be lionized in quite the same way.
Lincoln talked as much about the Declaration as he did the Constitution. He linked the two together.
Right. Actually, my former student, Rachel Sheldon Shapiro, teaches at Penn State, runs the Civil War Center there. Actually did her great senior thesis on this back, 27 years ago under my direction. But Lincoln's attitude towards Jefferson, Lincoln, the party that Lincoln wound up heading was not descended from the later the Democratic Republican Party that Jefferson and Madison had founded in the 1790s. But Lincoln gave Jefferson a lot of credit. A lot of that just pivots on making equality, the leading claim in American political literature. But equality, as I've written myself in various places, is an extremely powerful concept. And once you apply it to one realm of behavior, it's hard not to apply it to others.
Well,
and once you make equality your dominant creed, instead of accepting hierarchy, whether it's based on race, class, gender, sexuality, ethnicity, religion, whatever, once you make equality your founding principle, it always remains a useful concept.
I'm going to do a special series of episodes about the Declaration of Independence, in which I hope James Oakes, Sean Wilentz, and some others will join me. But you've written that when those words were penned, all men are created equal, they did not mean personal rights or civil liberties, that it meant as a people, the American colonists as a people had the same rights to self-government as other nations.
Yeah, that's a position I've long maintained. I think historically it's correct, but it has to be qualified in one way. So my main point is that the whole purpose of the Declaration of Independence was not to make individual equality for all citizens per se the dominant value in our political culture. The main purpose of the Declaration is to say that the Americans as a people, given the long train of abuses to which they've been subjected by British imperial rule, had a right, like other peoples, to establish their own governments, to secure the rights with which we are naturally endowed. So that was primarily, the statement is really a statement about the collective wishes of the American polity as a whole. It wasn't meant to be a creed that would make individual equality or civic equality across all kinds of categories.
It wasn't written as an abstract political treatise. It was written with a purpose to justify the break with the crown. We, as a people, have rights to self-government that we're being denied by this monarchy.
But Martin, the key thing is whatever the author, anybody who's written a book knows this is what happens anyhow. Whatever the author intends, or the original adopters intend, readers are still free to apply their own meaning and interpretation to what the words say. So what I was trying to say is the Declaration was written for still a pretty broad purpose, but a little bit narrower than many Americans have read it. But so what? Over time, the popular reading has become the dominant one.
And I think we forget that radicalism. Gordon Wood's book, The Radicalism of the American Revolution, the title is an argument. It was a break with the past. It was a revolution. It overturned the existing order. I think that's lost on people today, a little bit, depending on which side of the political spectrum they might fall.
Well, it wasn't lost on me because Gordon left a manuscript of the book on my doorstep after he finished a year at Stanford up at the Behavioral Science Center.
Wow. And Bernard Balin was
where he wrote most of it.
And Bernard Balin was your mentor.
Bernard Balin was my mentor. Yeah.
Wow. Well, that book that you mentioned, that's ground zero.
Yeah.
For me, anyway, to understand the American Revolution. That's the first book that should be read. Maybe I can't make that claim that there's only one book to begin with, but that's as good as any that I can think of anyway.
I think Balin was the most influential, cosmopolitan, intellectually powerful historian of the 20th century. He certainly transformed my career, that of many others. But Ideological Origins is just a fabulous book. It's not his best book, though. His best book is actually his biography of Thomas Hutchinson, the next to last royal governor of Massachusetts. But his most important book is Ideological Origins.
Jack Rakove, we thank you. He is the author of, among many books, Revolutionaries, A New History of the Invention of America. And the one we were just referring to, consider reading that as a personal challenge before the July 4th holiday. The Ideological Origins of the American Revolution by Bernard Balin. On the next episode of History as It Happens, the images coming out of Bakhmut, Ukraine, evoke memories of the Second World War, but you don't have to go back to the 1940s for scenes of utter devastation. What about Grozny in Chechnya in the mid-1990s? That's next as we report History as It Happens, a podcast from the Washington Times.